I seek your lordship indulgence in making a mention in respect of item number 1 of part 2, my lord. Item number 1 of part 2.
Yes.
On the last occasion, my lord, we had fixed this matter for to be taken about 26th, this Tuesday, but due to some difficulty, my lord, that cannot be taken up. And this may be taken up after 2 weeks, my lord, on the consent of both the parties. After 2 weeks.
As paid for by Mr.
Item 1.
As paid for by Mr. Victor L. Ralte, learned counsel for the petitioners and not objected to by the other side. There's this matter for hearing after 2 weeks.
Deeply obliged.
May I seek your lordship indulgence in mentioning part 2, item number 7.
Yes.
My lord, if the matter can be taken up after 2 weeks.
Okay. Your good name?
No, Ropari.
As paid for by Miss Lal Ropari, learned counsel for the petitioner and not objected to by the other side. List the matter for hearing after 2 weeks.
Oblige.
May I please, your lordship?
Yes.
Yes, lordship, I beg to mention item number 2 of the hearing list, lordship.
Yes.
It was actually, lordship, fixed on 26, but unfortunately it could not happen. Lordship, may I seek a accommodation on 11th, lordship? I have talked to the other party also, other side, lordship.
Yes.
I am for the respondent number 2.
Any objection?
No, my lord.
Okay. Your good name?
T.A. Chaudhary, lordship,
Okay.
Tahir Ahmed Chaudhary.
As paid for by Mr. T.A. Chaudhary, learned counsel for the appellants and not objected to by the other side. List this matter for hearing on 11th of September 2025.
Lordship.
Okay.
Highly obliged, lordship.
May I seek your lordship indulgence in making a mention with respect to part 2, item number 5.
Yes.
Yes, my lord, if this matter may come up after 3 weeks.
Okay. As paid for by Ms. Rosie Manlomsani, learned counsel for the petitioners. List this matter for hearing again after 3 weeks.
Oblige.
May I seek your lordship's indulgence in making mention of a non-listed item, my lord. My lord, we have been given instructions to withdraw this case, my lord. It is, we are the petitioner in WPC number 45 of 2025, my lord. So if this may be, if we may be accommodated today, my lord.
You want to withdraw it?
Yes, my lord, if we are given the chance to withdraw with liberty to file afresh, my lord.
Why you want liberty again?
My lord, right now the departmental inquiry is going on, my lord. And every time there's an order that's coming out, we'll have to file an affidavit so that it might be difficult, my lord. So,
Okay.
yes,
Today,
yes, my lord.
make a supplementary list.
Oblige, my lord.
Motion, item 1.
Yes, Mr. Johnson.
If you please, your lordship, this matter involved the illegal deduction of the 15% cess from the compensation awarded to the petitioners, your lordship, under the central enactment, which is the National Highway Act of 1956, your lordship. My lord, the petitioners' land, which were located at Bilkotlir and Gosen Vang of Kolesip district, your lordship, were acquired for widening and construction of the National Highway 306 and National Highway 06 under the provisions of the National Highway Act. Thereafter, your lordship, the notification which was published in the Gazette of India under section 3A for initiating the acquisition was issued by the Union government on, my lord, if the date will be reported, on 13/5/2021. So the notification was, then thereafter, your lordship, the substance of the notification was issued in the 2 local newspapers and objections were invited. And after hearing of the objections, your lordship, thereafter notification under 3D of the National Highway Act was issued in the Gazette of India on dated 30/12/2021, your lordship. Section 3D, subclause 2 of the National Highway Act, your lordship, says that after, when publication of section 30D has been issued, your lordship, the land has vested absolutely in the central government. So the acquisition of the land has been completed under section 3D, Your Lordship. The only question now is the payment of the award, which is under 3G, Your Lordship. So after the land has been taken over by the central government, ownership has passed to the central government. Subsequently, Your Lordship, an award/order under section 3G and 3H was passed by the Kala Scholarship, Your Lordship, on 21/6/2022. And on 21/6/2022, the award was passed, Your Lordship, whereby in the award, 15% cess was deducted from the compensation entitled to the petitioners, Your Lordship. Your Lordship, at this stage, if I may kindly take Your Lordship to page 5 of my writ petition, Your Lordship. At para 3, we have given the table, Your Lordship, showing the amount of compensation which was awarded. And thereafter, Your Lordship, if I may kindly take Your Lordship to page 7. At page 7, the table will show in the right column the deduction of 15% cess, the amount which were deducted, Your Lordship. And, my Lord, since the land of the petitioners were acquired under the National Highway Act, the provisions of the right to fair compensation, which was the 2013 Act, has to be applied, Your Lordship, which provides for beneficial and adequate compensation, Your Lordship. So even though, my Lord, the land of the petitions were acquired under the Central Act, by invoking section Rule 47(4) of the Mizoram Land Revenue Rules 2013, which provides for deduction of 15% share, Your Lordship, State Act, it was illegally deducted, Your Lordship. And this Rule 47(4) of the Mizoram Land Revenue Rules 2013 was subsequently amended by notification 17/5/2019, wherein Land Acquisition Act, the word Land Acquisition Act 1894 was replaced by any land acquisition law or policy of the government of Mizoram for the time being enforced, Your Lordship. Unamended rules, Your Lordship, we have reproduced it at page 9, para 6, Your Lordship.
Yes, how does it read? Just read that.
Section 47, subclause 4 of the Mizoram Land Revenue Rules 2013, 47(4), Your Lordship. In the case of acquisition of land covered by house pass or stall pass or shop pass or periodic pata or land lease under the Land Acquisition Act 1894, as amended from time to time, compensation may be paid as per assessment by the concerned collector of the district, provided that the validity of the tenure of the state land holding has not expired. In addition to crops and building damage compensation, land value may also be assessed, and out of the assessed amount, 15% of land value shall be remitted to Revenue Department as assessed on the value of land. So, Your Lordship, you will see here that it is only in the first part under Land Acquisition Act 1894. Since the land was acquired under National Highway Act, to circumvent that, at para number 7, amendment was made.
No, please come to page 9.
Yes, Your Lordship.
Page 9, the last paragraph.
Yes,
The abstract of the section 47(4).
yes, Your Lordship.
Or this is rule or section?
Rule.
Okay, so it says, in case of acquisition of land covered by house pass or stall pass, shop pass or periodic pata or land, under Land Acquisition Act.
Yes.
So this has been amended.
Amended.
Instead of Land Acquisition Act, it says now that any land acquisition law or policy of Government of Mizoram
Yes, Your
for
Lordship.
the time being in force.
Yes, Your Lordship.
And your case is that your land has been acquired under the Highways Act,
Highway Act, Your Lordship.
which also corresponds to the Land Acquisition Act of 2013.
Yes, Your Lordship.
So the cess could not have been deducted.
Would not have been deducted. And Your Lordship, numerous judgment has been passed by Your Lordship. And if I may kindly take Your Lordship, and this is a cover matter, Your Lordship, to page 31, Your Lordship. this issue has been dealt at length, Your Lordship. Various judgments have been passed. Page 31, Your Lordship. I have annexed here with, Your Lordship, 4 orders, 4 judgments of this Honorable Court. This is a similar matter. Here, land were acquired under the National Highways Act, and 15% cess were deducted, Your Lordship.
So what was the direction there in that case?
To return, to give back the 50% cess, Your Lordship. If I may take Your Lordship to the portion which is vital, Your Lordship, is that from Parak 10, Your Lordship, if I may kindly deal.
Yes.
This court, if Your Lordship have it, Parak 10?
Yes.
Yes. This court in the order dated 24/9/2021 passing WPC number 86 of 2021 at Parak 13 has held as follows. On considering the above issue in WPC number 36 of 2021, this court in the order dated 8/9/2021 passed in WPC 36/2021 at Parak 14 has held as follows. Parak 14. In the present case, the petition's land have been acquired under the Railway Act 1899, which has been enacted by the Parliament. Also, the Government of Mizoram Land Revenue and Settlement Department issued a notification dated, notification number so-and-so dated 14/3/2018, which provides that during the period the Mizoram Land Acquisition, Rehabilitation and Resettlement Act 2016 is sub judice, lands for the national highway projects and railway projects in Mizoram shall be acquired under the relevant provisions of the National Highway Act 1956 and the Railway Act 1989 respectively. In view of the above, it is clear that as acquisition of the petition's land have been made under a central act, Rule 47(4) of the 2013 rules and Amendment Rules 2019 would not be applicable to the case in hand. Accordingly, the respondent number 1 to 3 could not have invoked the provisions of Rule 47(4) of the 2013 Act for deducting 50% cess from the compensation amount awarded to the petitions in terms of award number 3 of 2019. Consequently, the deduction of 15% cess by the respondent number 1 to 3 is illegal and not sustainable in law. A perusal of Rule 47(4) of the 2013 rules and the Amendment Rules 2019 clearly shows that cess cannot be deducted from the compensation amount awarded for acquisitions of lands made under the National Highway Act 1956. However, it is surprising to note that the state government has thrown caution to the wind and have deducted 15% of the compensation amount awarded to the petitioners, despite knowing that their actions are not sanctioned by law. The action of the state is illegal and arbitrary. Further, in the case of Union of India versus Tulsiram Patel reported in 1985, 3 SCC 398, the apex court has held that the source of power must exist for its exercise. However, the state respondents have not been able to show this court the source of power to deduct 15% of the compensation amount as cess in respect of the lands acquired under the central law. In view of the above, the invocation of Rule 47(4) of the 2013 rules and the Amendment Rules 2019 for deducting 50% cess from the compensation amount awarded to the petitioners in terms of award/order dated 10/8/21 is arbitrary and is accordingly set aside. The respondent number 1, 3 are accordingly directed to immediately release the deducted 50% cess to the petitioner within a period of 1 month from the date of receipt of a copy of this order, by depositing the state amount in the office of the concerned Deputy Commissioner/District Collector, who shall then disburse the amount to the petitioners.
See, one thing which I don't understand is why did we mention the perusal of Rule 47(4) of 2013 rules and the amended rules of 2019?
Yes, my lord.
Prior to the amendment, cess could have been deducted.
No, my lord. As we have read earlier, my lord, the state of government, the state has issued a notification saying that national highway projects and railway projects shall be acquired under the relevant provisions of the National Highway Act itself and the Railway Act itself.
No, I'm talking about the provision of this Rule 47(4).
Yes, my lord.
It says that in case of acquisition of land covered by house pass so-and-so, under LA Act 1894, compensation so-and-so, then 15% cess deduction.
Yes, my lord.
So 47(4) originally provided the deduction of cess.
Deduction of cess.
Only after the amendment came, that Land Acquisition Act was taken away. It says that any provision, acquisition provision of the state.
Yes.
So had it been acquired under any provision of the state, like we had the 2016 Act,
Yes, ma'am.
then they could have deducted the cess. But when the acquisition itself was done under the central enactment,
Central Act.
it cannot be
It cannot
deducted.
be. Because the National Highway Act has to be read with the Central 2013 Act.
That's correct. But then why did we mention this? A perusal of Rule 47 and 2030 rules and amended rules of 2019 clearly shows cess cannot be deducted.
It is because, Your Lordship, when the provisions of the National Highway Act and the right to fair compensation does not provide for any deduction of cess.
Okay.
It was acquired under the Central Act, which does not provide for any deduction of compensation. Now the state government, even though the land was acquired under the Central Act, has made an amendment to the rules whereby 15% was arbitrarily deducted, Your Lordship.
Okay, even prior to the amendment, the LA Act doesn't provide for cess deduction.
No, it does not provide. Your Lordship. And, Your Lordship, coming to
So when was the deduction made?
the deduction was made on 21/6/2022.
Now why we come now?
My Lord, it is a fact that the award, even though the award was made, my Lord, due to this case, environmental case, award was not disbursed, Your Lordship. The award was not disbursed immediately, Your Lordship.
When was it disbursed then?
It was disbursed in something around 2023, Your Lordship.
You don't have the date?
I don't have the date, Your Lordship, because it is given to the account directly to the landowners, Your Lordship.
You have not mentioned anywhere about the disbursal in the writ petition?
No, Your Lordship.
Yes, who is appearing for the other side?
Yes, Your Lordship. In this regard, Your Lordship, there is an appeal, writ appeal.
Writ appeal?
Yes, Your Lordship.
Where?
And it's in the division, before the division bench, Your
Where,
Lordship.
in the Aizawl bench
In
or
the
in the
Aizawl
principal
bench.
seat?
In the Aizawl bench. Writ appeal number 6, 2024.
Writ appeal number 6.
2024.
What is the order passed in the writ appeal?
There is no order yet, Your Lordship. It's
Has it been
pending.
admitted?
Admitted. Admitted. And
There's no
it's pending.
stay?
No stay.
Then?
So, if the matter,
My Lord, if I may, my learned friend is mistaken, Your Lordship. That writ appeal is concerning Section 75 of the Mizoram Land Revenue Rules, Land Revenue Act, Your Lordship. This is concerning Section Rule 47, which will come in the
Section?
Rule 47.
No, Rule 47 we are clear. The other case,
My
the
Lord,
writ appeal?
My Lord,
The writ appeal is regarding what?
Your Lordship,
My Lord, if I may, that will come in the item number 2. We have filed two matters, Your Lordship. The fact is like this, Your Lordship. The court has earlier passed orders declaring that it is illegal to deduct 50% cess, and many orders were passed by this honorable court to return back the cess, Your Lordship. Now the state of Mizoram, thereafter, in order to circumvent the order of this court, again inserted a new section, it is Section 75A, into the Mizoram Land Revenue Act, Your Lordship.
Since when?
In 2022, Your Lordship.
75A.
75A, Your Lordship.
Okay, what does it say?
Thereby, the new section was inserted to say that 15% cess will be able to be deducted again. Earlier, it was only the rules. Now, the state legislature has inserted a new section, which will come in the next, Your Lordship, item, Your Lordship. Thereby, allowing 50% to be deducted again. Now, that case, and here the difference is that this award and acquisition was passed before coming off before the legislature was, the new amendment rules were passed.
75A.
75A, Your Lordship.
75A, by which amendment?
It is an,
What is the date? Give me the second file, the next, number 2. Item number 2.
my Lord, if I may take you to page 78.
79.
70.
No, 75A.
Yes, yeah.
75A.
At page 78.
Page 80. Page 80.
Yes, Your Lordship. Yes, Your Lordship.
Serial number 9.
Yes, Your Lordship. So, Your Lordship,
So this notification has come with effect from?
from the date it was published in the Mizoram Gazette, that is 23/9/2022.
Okay.
So the earlier judgments which we have rendered by this court was in 2021, Your Lordship. So to circumvent that, this Amendment Act, the Mizoram Land Revenue Amendment Act 2022 was passed, whereby, and Your Lordship will see that at section 1, subclause 3, at page 78, it shall come into force on the date of its publication in the Mizoram Gazette.
Oh, that's correct.
Yes. And at 9, section 9, no, 9, the insertion of the new 75A, Your Lordship. So the acquisition of land covered by house passes, so and so, which was earlier the same thing, and this section 75A 2 was inserted, Your Lordship. Now, my lord, on to the next page.
Yes.
On to the next page. In exercise of the powers under 75A, this is subsequently after it
No,
was
from where are you saying that?
page 82.
Yes, 82.
Page 82. So, Your Lordship, after this Amendment Act was passed, on 20, it was passed on September of 2022. Thereafter, on November 23rd, 2022, this notification was issued. And in exercise of the powers conferred under 75A4, so and so, the government of Mizoram is pleased to notify, here, Your Lordship, retrospectively with effect from 23/9/2022, which is the date on which the Amendment Act came into being,
Yes.
that 50% share of the government as stipulated under subsection 1 and 2 of the 75A of the said Act shall be collected from land acquisition made under the following acts. And Your Lordship will see at 2, the National Highway Act.
Everything is there.
Yes. So, this was made specifically by the government to circumvent the order passed by, several orders passed by this honorable court. And my lord, before we move on to
So why have you filed this writ petition? Item number 2.
item number 2, Your Lordship,
You have challenged this provision.
not challenging this provision, my
Then-
lord, here also in item number 2, our lands were already acquired prior to this Amendment Act.
When was it acquired?
It was notification under section 3A was issued on 24/3/2021.
But the award was passed on 5/12/24.
Yeah. My lord, like I said before, like I've submitted before, under section 3D was issued on 4/1/2022. And before that, there are two section 3D, 30/12/2021. Under 3D, declaration was issued, which says that all the acquisition has been completed, the land ownership has passed on to the central government in 2021.
It becomes complete from which stage? 3D.
From 3D. After 3D, the only thing is to pay the compensation, Your Lordship. So if I take Your Lordship to 3D, Your Lordship, of the National Highway Act, Your Lordship, if I may take.
Yes, 3D.
Yes, 3D, Your Lordship, 3D subclause 2. So, on publication of the declaration under subsection 1, the land shall vest absolutely in the central government free from all encumbrances. And
So when was the declaration published?
declaration published on 30/12/2021.
30/12/2021.
Yes, Your Lordship.
So these both item 1 and 2 are similar.
Not similar in the sense that they are not identical. Item 1, cess was deducted prior to the coming of this Amendment Act. It was deducted by Section 47(4) of the rules.
Then the second item?
The second item was deducted by invoking the newly inserted
Amended. Okay.
section.
And your case is that 3D had already been published.
Published already in.
So 3D was already published, so they could not have invoked this.
They could not have invoked this.
Section, what is that?
75A.
75A.
Your Lordship. Due to the, like I've said before, I've submitted before, due to the environmental issues, the award was not passed for 2 years, Your Lordship. It was only passed in 2024. But the possession was already taken. The petitions were not allowed to make improvement on the land. Under 3A notification was issued, declaration under 3D was issued.
You have any authority saying that once 3D is published,
Yes, Your Lordship.
things are final?
Yes, Your Lordship. Tarem Singh, Union of India versus Tarem Singh, Your Lordship. 2019 9 SCC 304.
2019, 9.
9 SCC 304.
Which is the relevant para?
My Lord, here the whole section have been reproduced, and I'll take Your Lordship to para 10. 320, page number 320. And para 21 also it has been reiterated.
Para 10?
Para 10, Your Lordship. If I may kindly. Keeping in view the object of reducing delay and speedy implementation of highway projects, the amended National Highway Act does away with any award by way of an offer of land owners. Post the notification under 3A. Objections are to be heard by the competent authority whose order is then made final. The moment the authority disallows the objection, a report is submitted to the central government, and on receipt of such report, the central government by a declaration states that the land should be acquired for the purpose of mentioned in Section 3A. The important innovation made by the Amendment Act is that vesting is not postponed to after an award is made by the competent authority. Next part is important. Vesting takes place as soon as Section 3D declaration is made. One other important difference between the Amendment Act and the Land Acquisition Act is that determination of compensation is to be made by the competent authority under the Amendment Act. So, Your Lordship, the important innovation made by the Amendment Act is vesting is not postponed to after award is made by the competent authority. The award may be delayed for 1-2 years, Your Lordship, but vesting, that is vesting of the ownership, takes place as soon as 3D declaration is made, Your Lordship.
What do you mean by vesting?
That, Your Lordship, we come to the 3D, it says that, Section 3D says that, Your Lordship, vesting means the land shall vest absolutely in the central government, free from all conflict. That means the ownership has passed. Even though award has not been paid, if 3D is published in the Gazette of India, Your Lordship, the land shall vest absolutely in the central government. So when the land was already acquired in 2021, then thereafter in 2022, after vesting has already taken place, acquisition has been done, a new law has been inserted which allowed for 15% deduction, Your Lordship. Now, that new rules have been invoked to the land which has already been acquired, Your Lordship. That cannot be, Your Lordship. The state cannot make law regarding land acquisition which is detrimental to the landowners, Your Lordship. That will be a violation of Article 30A of the Constitution of India as well as the Article 14, Your Lordship. And in this
30A or 300A?
300, sorry, Your Lordship.
See, the first item is regarding invoking of this 47(4).
My Lord.
47(4).
Yes. Which has been declared.
Your Lordship,
By
if I
God.
may, these rules regarding that Rule 47 subclause 4, this has been challenged back in the year 2014. before the division bench in WPC 122 of 2014. And in this case, the states were permitted to deduct the cess amount of 15%. And that judgment in order has been remained unchallenged till now.
What is that?
The judgment in order was passed on 2019.
Where is the judgment? Show me.
Your Lordship, if the matter may be listed on Monday and the judgment may be produced by me. I have the judgment, but today I didn't bring that judgment.
No, see, I think there's some judgments enclosed with this writ petition also, wherein,
The judgment which I have mentioned has not been disclosed here.
I know, how can there be contradictory judgment? The court, this court has held that you cannot impose cess in view of the amendment. Earlier, it says Land Acquisition Act 1894. Even Land Acquisition Act 1894 does not provide for any provision for imposition of cess. Then you come up with the amendment of Section 47(4), Rule 47(4), which says that under state enactment. Now, admitted position is that acquisition was done under the National Highways Act. So plainly, it appears that it is not applicable. And cess could not have been deducted. Now, belatedly, you have come up with an amendment inserting Section 75A, wherein you have enclosed all the list of enactments.
Exactly.
Any acquisition made under these laws, you can take cess.
Yes,
But the
Your Lordship,
argument placed now before this court is that since 3D was already pronounced, notification that 3D was already pronounced prior to the amendment, so acquisition was complete. Maybe payment of compensation came later on, but acquisition was complete, so you could not have deducted.
Yes, Your Lordship, in the
So
notification.
that is where we are at. Now you come up with another judgment saying that
2019.
court has permitted deduction of cess.
This judgment which I have
you
mentioned.
sure? Are you
I'm
sure it's like that?
I'm sure. I'm very sure of that. There is a judgment
Then
before
why
the
did,
division
why
bench.
did the court pass this kind of order then?
Because it was never disclosed before the
No.
before the court. This judgment,
See, there are a number of judgments
this
enclosed here.
2019 judgment.
How come it's contrary to all these? The first judgment came in WPC 66, I think,
Yes, Your Lordship.
66 of 2022.
No, 2021.
I'm sorry, yes.
Passed by Your Lordship way back in 2021. What my learned friend has said was in 2019.
2019.
That cannot be, Your Lordship. I don't.
There is, Your Lordship. Before the division bench. And the case number is WPC 122 of 2024.
24.
122 of
2024. Or 2014. Sorry, Your Lordship.
40.
2014.
WPC before division bench.
Yes, Your Lordship.
How is that? Some rule was challenged?
This rules was challenged. And
Can
the
you take a printout?
And the division bench upheld the rules, permitting the state government to deduct the cess amount of 15%. 122 of 2014.
Mr. Jonathan,
Yes, Your Lordship.
item number 1 is regarding the invoking of section 47(4), isn't it?
Correct, Your Lordship.
And the others, item number 2 is regarding invoking of 75A.
Correct, Your Lordship. That's correct, Your Lordship.
But this 75A came after that 3D,
After the 3D.
in item 2 also.
Item 2 also, Your Lordship.
See, today being the first day, perhaps we'll
Yes, Your
examine this
Lordship.
aspect.
Just for Your Lordship reference,
And,
I just
Your
want
Lordship-
to make Your Lordship, it is regarding the retrospective effect of law, which for generally the Supreme Court, Your Lordship, if I may take Your Lordship, just for perusal, Your Lordship. In G. Mohan Rao and others versus State of Tamil Nadu and others, 2022-12 SCC.
This is regarding,
Retrospective effect.
yes, read the provision. What does it say?
It says that, Your Lordship, there cannot be expressed or declaratory overruling of the judgment of the court by the new state legislature, Your Lordship. The court has passed numerous judgments. Now to circumvent that, a new law has been, which is basically the same with the old law. So it is just that the timing of inserting the new 75A is to circumvent the judgment passed by this honorable court, several judgments passed by the court. Because in the judgments, it is basically the same, 50% share of the state government, 50% cess. And so, and my lord, the 2013 Land Revenue Act, if we read the objection reasons, it does not involve any cess reduction, Your Lordship.
Anyway, Mr. Jonathan, you see, that is another aspect of the matter.
Yes, Your Lordship.
Now, state in its own wisdom can enact laws, okay?
Yes,
But of course, it cannot go retrospectively.
Yes, my lord.
To circumvent the court's direction, it cannot say that it will be effective from before the judgment passed by this court. It cannot be that. That will be
Exactly,
struck
Your
down.
Lordship.
But it can definitely go prospective unless it is challenged and struck down by the court.
My lord.
It can be challenged. In appropriate case, you can challenge.
Yes.
This is a beneficial legislation wherein a person is required to get his due compensation
My
in
lord.
terms of law. And here is a thing in which the state has imposed upon itself that they should get a share of 15% out of the compensation.
I don't think there's any other law in the state of India, Your Lordship, taking.
So you take it up in appropriate cases, you see. But we cannot go to that extent in this case. We'll restrict yourself to your claim of cess refunding.
Yes, Your Lordship.
As of today, I think we'll issue notice, okay? And let Ms. Van de Semi also produce
Yes, Your Lordship.
whatever judgment she wants to rely upon.
My learned friend is having an objection regarding the item number 2, but regarding item 1, Your Lordship. That matter is a cover matter, it's a settled matter, Your Lordship. No appeal has been filed against the judgment of this court regarding Rule 47, Your Lordship. So if a differentiation may be made at this point that notice can be issued regarding item 2, because it's a new amendment, but regarding item 1, not to talk of the 3D, even the award was passed before the bill was laid before the legislature, Your Lordship. So it is clear that the Amendment 75 Act has not come into being when the award was passed, let alone the 3D, Your Lordship, regarding item 1. Item 1, Your Lordship, the 3D was passed in December 30th, 2021. Then amendment was, award was made on 21/6/2022, Your Lordship.
Ms. Van de Semi, there's
Yes,
some
sir.
distinction. 1 and 2, there's some distinction.
Yes, one is regarding the rules.
1 appears to be covered.
Your Lordship, if I may be given time, because I have to file that judgment and order which I have mentioned before. And that judgment and order has not been produced before this
Okay,
honorable court.
Okay then.
Previously.
We'll issue notice at this stage then.
Yes,
All right, Mr. Jonathan L. Silo, Learned Counsel for the petitioners, who submits that the petitioners are aggrieved with the deduction of cess at the rate of 15% from the compensation to be received by them. Full stop. He submits that the petitioners are owners of their respective land at Bilkotlir and Gosen Veng, Kolasip district. Paragraph 2 you'll find. Which was acquired for the purpose of construction and widening of NH 306 and NH 06 under the provisions of the National Highways Act 1956. Bracket, Highways Act, close bracket, full stop. He submits that a notification under section 3, capital A, bracket 1 of the Highways Act was issued on 13/5/2021 and thereafter under section 3, capital D on 30/12/2021. Stop. The Learned Counsel submits that under section 3D, on the publication of the declaration of acquisition, the land is to vest absolutely in the central government and free from all encumbrances. Full stop. Despite the same, the state respondents have deducted cess at the rate of 15% of the compensation amount in terms of Rule 47, bracket 4 of the Mizoram, open bracket, Land Revenue, close bracket, Rules, 2013. Stop. The Learned Counsel submits that the Rule 47, bracket 4 was amended by notification dated 17/5/2019. By which the word, open inverted comma, Land Acquisition Act, 1894, close inverted comma, was substituted by, open inverted comma, any land acquisition law or policy of the government of Mizoram for the time being in force, close inverted comma. Full stop. Full stop. Since the land of the petitioners have been acquired under the central enactment, the deduction of cess from their compensation amount is illegal, and the same should be refunded. Next para, at this stage, Ms. Vanesiami, learned government advocate, submits that deduction of cess has been held to be permissible by the division bench of this court in WPC number 122 of 2014. And she prays that she may be given the chance to rely upon the same. Next para, be that as it may. No, stop. Be that as it may, you cut that, okay? Whereas on the other hand, the Mr. Jonathan L. Silo, learned counsel, submits that the case of the petitioners is squarely covered by the earlier decision of this court, which has already been annexed in the writ petition. We'll stop. Next para, be that as it may, let notice of motion be issued, returnable by 2 weeks. Ms. Vanesiami, learned government advocate, accepts notice on behalf of respondent numbers 1 and 2. While Ms. Zaram Sankui, learned CGC, accepts notice on behalf of respondent number 4. Stop. Mr. Samuel Valrehe Changte, learned standing counsel, NHIDCL, accepts notice on behalf of respondent numbers 5 and 6. Petitioners to take steps for service of notice upon respondent number 3 by registered post with AD due within 3 days. 3 working days. Okay. Petitioners shall also furnish requisite extra copies of the writ petition to the learned counsels appearing today, if not already done. List the matter again after 2 weeks.
Item 2.
Heard Mr. Jonathan L. Silo, learned counsel for the petitioners, who submits that by filing this writ petition, the petitioners have sought for a direction to the respondent authorities concerned to refund the 15% cess deducted from the compensation amount to be received by them, along with interest. Stop. The learned counsel submits that the petitioners are owners of their respective plot of land covered by valid pass issued by the state government and located at Kolosip, North Thingdol, Bualpui and Konpui in the district of Kolosip. Paragraph 2, okay, you'll find. Stop. The respondent authority is concerned for the purpose of widening and maintenance of the National Highway 306 and 06
My Lord, just for clarification,
Yes.
since this land, the land in Kolosip and North Thingdol falls under package 5, and the lands under Bualpui and Konpui falls under package 6. So there are two notifications, Your Lordship, two 3A notifications and two 3D notifications. Your Lordship. So we have in para 3, the earlier notification under 3A will be 24/3/2021, and thereafter 13/5/2021. Just for clarification, Your Lordship.
First off, the Learned Counsel submits that the development of the National Highway has taken place in two packages, namely package number 5 and package number 6, and for which two separate notifications have been issued on 24/3/2021 and 13/5/2021 under section 3 capital A bracket 1 of the National Highways Act. Stop. Consequently, a notification under section 3D of the National Highways Act was issued on 30/12/2021. 3D is only one or two?
Two.
What is the other date?
4/1/2022. 4th January 2022.
Where do you get that?
Para 5.
Okay. On 30/12/2021 and 4/1/2022. And this 75A came into force from which date? 4th January.
23
23/9.
29, 2022.
Full stop. The Learned Counsel submits that the case of the petitioner is squarely covered by the earlier decision of this court, that is order dated 8/9/2021, passed in WPC number 36 of 2021, open bracket, N. Vanlalngaka and 10 others versus State of Mizoram and 4 others. Page 89, okay? You'll get this name. Stop. The Learned Counsel, however, submits that in the meantime, the state respondents have come with an enactment had come with an amendment of the Mizoram Land Revenue Amendment Act 2022, which was notified in the Mizoram Gazette on 23/9/2022 by inserting section 75 capital A, which provides for deduction of 15% cess from the compensation to be received. Full stop. The Learned Counsel submits that since the enactment has come after the publication of notification under section 3D, comma, 15% cess cannot be deducted from the compensation amount to be received by the petitioner at any rate. Stop. He therefore submits that direction may be given to the respondents to release oblique refund the cess amount to the petitioners. Next para. In view of above, issue notice returnable by 2 weeks. Ms. Vanessiami, learned government advocate, accepts
Your
notice
Lordship.
on behalf of respondent numbers.
Your Lordship, in item number 2,
I'm sorry, Ms. Lalnun Louis, rewrite. Ms. Lalnun Louis, learned government advocate, accepts notice on behalf of respondent numbers 1 and 2.
yes, Your Lordship.
Ms. Zairem Sangpui, learned CGC, accepts notice on behalf of respondent number 4. Mr. Samuel Valfried Changte, learned standing counsel, NHIDCL, accepts notice on behalf of respondent numbers 5 and 6. And the petitioners shall take steps for service of notice upon the respondent number 3 by registered post with ADD within 3 working days. This again after 2 weeks.
Much obliged, Lord.
Orders, item 7.
Please, Your Lordship.
Yes.
This is the first time this matter has been listed today. This is a bail application filed under Section 37 of the ND&PS Act 1985.
Use the microphone.
Yes, my,
Pulia.
yes, my lord.
Yes.
This is the first time that this matter has been listed today.
Okay.
And this is a bail application filed under Section 37 of the ND&PS Act, read with Section 483 BNSS for enlargement of the applicant on bail. The applicant was arrested on 23rd/1/2023 at 5:50 p.m. by the police personnel for alleged possession of 1,458 grams of heroin. Prior to filing of the instant bail application, the applicant had filed bail application number 889 of 2023, bail application number 350 of 2024, bail application number 738 of 2024, bail application number 1128 of 2024, arising out of SRP 130 of 2023 under Section 21C, 25, and 29 of the ND&PS Act 1985.
So, how many bail applications earlier? 4.
Yes, my lord, in the ND&PS court. And before
Before
this,
NDNPS court, four bail applications.
Yes, my lord.
And before the High Court,
2 bail applications.
what are they?
Bail application number 32 of 2023 and bail application number 72
Okay.
of 2023.
Okay. Now, what is the special ground today to seek bail?
My lord, the special ground is that there's violation of Article 22(1) of the Constitution of India, and this grounds has been raised for the first time.
Are you sure?
Yes, my lord.
Was it not your contention the last time also?
No, my lord.
Violation of Section 20,
Article 22(1) of the Constitution of
Article
India.
22(1). What is Article 22(1)?
It's regarding the grounds of arrest to be informed to the applicant.
And you have an authority on that?
Yes, my lord.
What is that?
Vihan Kumar versus State of Haryana and another 2025 5 SCC.
Okay. Vihan Kumar,
Yes.
Vihan Kumar's case.
Yes, my lord.
This has become a popular case, isn't it?
Yes, my lord.
Will issue notice as of today? Hart Miss
Sarah Remrod Feli.
Sarah
Remrod Feli.
Nalruat Feli, learned counsel for the applicant, who submits that by filing this application under Section 37 of the ND&PS Act, read with Section 483 of the BNSS, the applicant seeks grant of bail. Stop. The learned counsel submits that the applicant was arrested on 23/1/2023 in connection with alleged recovery, public possession of 1,458 grams of suspected heroin. and pursuant to which case was registered, namely SR bracket P number 130 of 2023 under section 21 bracket capital C /25/29 of the NDNPS Act. First of the learned counsel submits that the applicant submitted 4 bail applications before the trial court, which were all rejected. First of likewise, the applicant also submitted 2 bail applications before this court, and they were also rejected. The learned counsel submits that the applicant is now before this court seeking bail on the ground that section 22,
Article
22
1.
bracket 1 of the Constitution of India has been violated. In other words, the grounds of arrest has not been informed to the applicant. In support of her submission, the learned counsel relies upon the case of Vihan Kumar versus State of Haryana and another, reported in 2025, 5 SCC. What is the page number?
Yes, ma'am. Page number 816.
816. Next para in view of above, we issue notice. Returnable by 10 days. Ms. Vanesiami, learned resident public prosecutor, accepts notice on behalf of the state. Applicant to serve requisite copies of the bail application to Ms. Vanesiami, if not already done. List again after 10 days on a date to be fixed by the registry. We'll see what can be done about the date, because next week I'm not here, that's why.
Oblige you.
Item 8.
May it please your worship. The respondent number 1 in the contempt case has recently been transferred out, and there's a new incumbent in his place. So this is an application for impleadment of the new incumbent in the post of exit. Your worship, in the prayer portion at page 4, his name is a bit difficult to pronounce. Mr. Adelbert Susni. He's the new incumbent.
Very unusual name. Isn't it?
Yes.
Adelbert Susni.
Adelbert Susni. So he's the new incumbent. So he needs to be impleaded, Your Worship.
As respondent number?
4.
Okay. And who was for the other side? Anyone? Any objection?
My lord, I have instructions to appear on behalf of the newly to be impleaded.
Okay, very good. And what is this writ appeal disposed?
Your Worship, in fact, Your Worship, the writ appeal was disposed even thereafter. The review petition which was filed by the NHIDCL has also been dismissed. This is regarding, Your Worship, the review of the award passed by Kala, Competent Authority. The Kala had pronounced an award under the Highways Act. Subsequently, it was revised by Kala, and the revision was challenged by us by stating that it is beyond his power since there is no review power under the Highways Act. So the initial award has to stand. And this Honorable Court had passed a judgment setting aside the revised award. They had filed an appeal which was also dismissed. They in fact approached the Supreme Court also by filing an SLP which was withdrawn, and they filed a review petition against the writ appeal. That was also dismissed. So this is a contempt petition for non-compliance of the judgment of the Honorable Court.
So what is your instruction, Mr. Zakima?
My lord, I have only instructions to appear and accept notice on behalf of the newly to be impleaded respondent.
You should get
And
complete instructions.
I will be filing my...
By which time you're going to pay the money?
That, my lord, I will receive instructions.
These are small things,
Yes, my lord.
implement, this, that, and all that. Main thing is the money. They want
My
the
lord,
money.
My lord, exactly.
You have exhausted all your remedy. What else can you do? Where else can you run now?
My lord, I will...
You're cornered from every angle. Heard Mr. A.R. Malhotra, learned counsel for the applicant, who submits that by filing this application, the applicant seeks implement of Shri Adelbert Susni. Page 4, Executive Director, NHIDCL, as respondent number 4, since he is the new incumbent holding the said post. Of the learned counsel submits that implement is necessary for effective compliance of the court's order. At this stage, no, next para. Issue notice, no, not required. Considering the submissions made and on perusal of the application for implement as paid for is hereby allowed. IS stands disposed of. Then in the main contempt you write, in view of the order passed today in IAC number 154 of 2025, a petitioner to file the amended cost title in 2 sets before the registry of this court within 3 working days. Next para, issue notice to the newly implemented respondent number 4, returnable by 2 weeks. Stop at this stage. Mr. T. Lal Zekima, learned counsel, submits that he has the instructions to appear on behalf of the newly implemented respondent number 4. Stop. In view of, as such, formal notice is waived. Petitioner to serve copy of the writ petition with the amended cost title.
Contempt petition.
Of the contempt petition with the amended cost title to Mr. T. Lal Zekima within a week. List the matter again after 2 weeks.
Joshua, if I may, Joshua, there's already a fixed date in the contempt petition. So,
what is the date?
Joshua, I think it was, last order was, I think, after 2 weeks. On a date to be fixed by the registry, I think, if I'm not mistaken.
What is the order date? 18/6?
Yeah, last week, I think, in August, Joshua.
In August?
Yes, in the contempt, in the main contempt petition.
After 4 weeks, it says.
Okay.
Okay, then you write, list the matter in terms of the order dated 19/8/2025.
I'm on that.
Okay.
Item 3 and 4.
Please, Your Lordship.
Yes.
Lordship, in this matter, we have prayed for acquisition. On the last date, my lord, a preliminary notification copy was served on us, my lord, and it has also been taken on record. May I pray, my lord, if this matter is kept pending, my lord, because from the experience in other matters, my lord, sometimes they withdraw the preliminary notification and acquisition doesn't transpire. If it could be kept pending for some time, my lord. The declaration is not yet out, my lord.
Acquisition will be under what provision of law?
Under the 2013 Act, my lord.
2013. And what are the steps to be taken?
My lord, after this, the declaration has to be issued, the survey declaration, my lord, and thereafter award. My lord, the market value has to be determined. And
1894 Act, we have this section 4, 6, 9, all that. Now, what is the steps here in 2013?
My lord, almost the same, my lord, the section 11 and section 19.
Preliminary notification comes under what provision?
Under 11, my lord.
11.
11.
That has been done.
That has been done.
Now,
27th of May.
what is the next?
My lord, declaration.
Declaration.
Declaration, and thereafter the market value has to be determined.
Okay.
And then, my lord.
Yes, any updates?
No updates yet.
Is the time factor relevant in this case? The entire proceeding has to be done within a particular
Yes, my
period of
lord.
time.
If it is not done within a period of 1 year, my lord, it
Lapse.
would lapse.
1 year.
1 year, my lord.
So preliminary notification is 27 May.
My lord.
Now, who is issuing all this? It's by the state or by the collector?
By the, this is by the state, my lord, by the Secretary, Land Revenue and Settlement.
Okay.
A copy is marked as Annexure X, most probably, my lord. Marked as Annexure X, my lord. Marked as X, sorry, my lord, not Annexure.
Secretary Revenue.
My lord.
You find out what has happened after this? Mr. P.D. Nair, Learned Counsel, appears for the petitioners. And Ms. Linda L. Fumble, Learned Additional AG, appears for the state respondents. While Ms. Zairam Sangpui, Learned CGC, appears for the Respondent Union of India. Matter pertains to acquisition of land. What is the name of the place? Komzol?
Komzol in Lunglei,
At Komzol in Lunglei for
Assam Rifles.
settlement of the Assam Rifles. Stop. A preliminary notification was issued on 27/5/2025. Under Section 11 of the
Right to
right
fair
to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013. Bracket, Act of 2013. Stop. However, what further steps have transpired thereafter is not discernible. Full stop. In view of above, the Learned Additional Advocate General shall obtain instructions in this regard by the next date. List again on so and so.
But if it could be on 10th of October, my lord.
10th of
October.
October. 10th of October. It's Friday.
Friday.
It's not a holiday here, is it?
Yes, my lord, it's not a holiday here. In the principal seat, it's a holiday.
Is there any short form for this act? Pronunciation? So,
My lord, we
the other
call
day
it
somebody had pronounced some referral act or something, I don't know what was.
RFCT LARR or sometimes LARR Act, my lord.
RFCTL.
LARR.
Okay. Every time you get confused.
My lord.
Yes.
Deeply obliged.
Item 5.
Lord, in this matter, I was supposed to take instructions, my lord. Some information had been sought for under RTI, but we have not got the documents as yet, my lord. Could I pray for some more time, my lord,
Okay.
to reply to the affidavit, my lord?
Mr. P.D. Nair, Learned Counsel for the petitioner, submits that he is still awaiting the information which he has sought through RTI and prays for further time to receive instructions. In view of above, and as prayed for, let the matter be listed on 10th of October 2025.
My lord.
Ms. Zairam Sangpui, Learned CGC, appears for the Respondent Union of India. Mr. Samuel Vansri Changte, Learned Standing Counsel. Mr. Samuel Vansri Changte, Learned Additional AG, appears for the state respondents.
Deeply obliged.
Item 6.
My Lord, the respondents
are yet to receive the instruction as per the last court order.
Yes, Your Lordship, I'm seeking another 2 weeks' time to file my affidavit. in
What is the matter?
opposition. Actually, Your Lordship, this is
Rejection
this
of the
matter-
joint.
This matter is handled by Miss Mary El Kalte.
What is the matter?
The matter is rejection of the joint representation.
Only that, rejection of joint representation, no subject matter.
Is
My lord, it's with regard to the denial to
Financial upgradation,
upgradation, my lord.
MSCPS.
Yes, my lord.
Okay.
When the similarly situated person have been paid, my lord.
I see, you all working under the PhD.
Yes, PhD and PWD.
I see. How much time?
2 weeks' time, Your Lordship.
Okay, as paid for, Ms. Learned Government Advocate is granted further 2 weeks' time to obtain instructions and to file counter affidavit. List again after 2 weeks.
Obliged, my lord.
Unlisted item.
Yes,
My lord,
yes.
this matter was listed at the beginning of this week, my lord, and we have sought instruction to file affidavit as well, my lord. But as we have received from our client, a constitution of a board of committee of inquiry has been set up, my lord. And day-to-day proceedings are also ongoing, my lord. And the main issue of this writ petition, my lord, is quite similar with the present disciplinary proceeding. So if we may be allowed to withdraw the case with liberty to file afresh, my lord.
Okay, as prayed for by Mr.
David Lalompuya.
David Lalompuya, Learned Counsel for the petitioner. The petition stands disposed of as withdrawn with liberty to file afresh, if so advised.
Obliged, madam.
She's gone, she's left. Vanessa me. This thing. Jonathan is here, Mr. Jonathan. You check up this file. This is what she was referring to. I don't know whether it's relatable to your case or not. Just have a look. It's a division bench judgment. Okay, I'm rising.